Thank you for clicking this video. This is Batok with Ola. My name is Mujola Olua, and in this video I want to talk about the International Criminal Court, that is the ICC. Don't forget that I have a book published on Seller. It's a collection of 10 short stories that I wrote over the years. It's titled Inquit. Please look for it on Okada Books or Seller and buy it. It's 1,200 or its equivalent in your currency, and I appreciate everyone that has bought it so far. Thank you so much. I hope you find it a very enjoyable read, as I found it a very enjoyable write. If there's anything like that. So today I want to talk about the International Criminal Court. It's a court that was established, by the Rome Statute of 1998. So it's the first kind of it's the first of its kind. It's a court, the first international criminal court, that enjoys permanence. There were other international crime tribunals or international criminal tribunals post World War II, but they were established to try some sets of criminals, and they were temporary in nature. But this particular International Criminal Court was established to be permanent. So about 123 countries are members of the court. When I say members, it means that they have ratified the statute that established the court in their states. So they have submitted themselves to the jurisdiction of the court, 123. Several other countries have not. Like the United States is not subject to the International Criminal Court because they have not joined as a member, even though they are cooperating with the International Criminal Court. I'm going to be talking about that much later. But as we speak, there are 123 members of the International Criminal Court. It's a court that enjoys permanence, like I have said. It has structure, it has a jurisdiction, and it sits at The Hague in Netherlands. That's where the court is physically located. So this court is charged with trying crimes that are of international concern. The most serious crimes, grave crimes. So it's not a matter of armed robbery, kidnapping, all those crimes that can be tried locally. You cannot just say, oh, maybe I don't like my local court, I'm going to the International Criminal Court. It is a very serious court, and it tries very serious offenses. So the International Criminal Court does not usurp the jurisdiction of the local courts. What that means is that it operates on the principle of complementarity, and that also means that it only tries offenders when their local countries or states, their home states, are not able to try them or are not willing to try them. So for instance, someone has committed terrible crimes of grave and international concern. If the home state has the apparatus for trying that person, if the home state has laws that already criminalizes such acts, and they set the apparatus in motion to try that person, that offender, for that crime, you cannot take the person to the ICC. The ICC cannot try the person again. It is only when the local country or state cannot or will not try the offender that the ICC can step in and try the offenders. ICC began operation in 2002, but they opened their first case in 2009. The ICC started operations in 2002. That means that they can only try crimes that were committed after that date. They do not act retroactively. And just like criminal matters are not bound by statute of limitation, so matters brought before the ICC or matters over which the ICC has jurisdiction are not bound by statute of limitation. Statute of limitation means that maybe the law has said that if someone commits this crime and the person is not tried for maybe 2 years afterwards, or 7 years at least, or at most, after the commission of the crime, they can no longer be tried. That does not apply to the jurisdiction of the ICC. Matters can be tried at any time by the ICC. Now, the ICC will only try people that are 18 years and above. So people under 18 cannot be tried by the International Criminal Court. Also, people that are not offenders now, that are not, member citizens of a member country or a member state cannot be tried by the ICC. That means that, for instance, Nigeria is a member of the ICC. So if someone commits crimes that the ICC has jurisdiction over, they can be tried. But the United States is not a member of the ICC. So if a citizen of the United States commits offenses or an offense over which the ICC has jurisdiction ordinarily, that person cannot be tried. Now, the exception is that if the country or the state now submits to the ICC jurisdiction for the purpose of trying that person, then the person can be tried. So the United States can decide, oh, we are cooperating with the ICC, we would like the ICC to prosecute this offender that is our citizen. Then the ICC can actually try the person. So the ICC, the way people are tried is that, one, the country can refer a matter to the ICC. That is, okay, this person has committed so and so crimes in our country, so we're referring it to the office of the prosecutor at the ICC. Please open an investigation and try this person for these crimes. That's one. Two is the prosecutor at the International Criminal Court can decide that I want to open an investigation into this matter. Maybe they've been receiving complaints or they've been hearing some things or making some findings. So I want to open an investigation and I want to try it. Then the United Nations Security Council can refer. They can say, okay, ICC, open an investigation into this matter, try this person or persons for these crimes. So the ICC prosecutor will open an investigation, do their preliminary investigations, and then decide if there's a case and if the person should be tried or not. So the International Criminal Court is funded by member states, and then it receives donations and support from cooperating states. Now, a cooperating state is a state that says that, okay, we are not members, we're not going to ratify the Rome Statute. We're not members of the ICC, but we will support the ICC, maybe by personnel, we'll give the ICC our soldiers when the ICC needs it. If the ICC requires us to train their personnel, we will train them, or we will provide funding for the ICC. So countries that are not members can cooperate, and then there are member countries that are part and parcel of the International Criminal Court. So far, the International Criminal Court has tried 31 Africans. So there are insinuations and suggestions that, oh, is this court focused on Africa? After all, Africa only has 33 countries out of the 123 countries that are member states. So why this particular focus on Africa? It is what it is. 31 cases so far. There have been some convictions, some cases the charges were dropped, some cases have been appealed. And there are open cases whereby the ICC has not been able to, make an arrest, even though there's been a warrant of arrest. For instance, in the case of Muammar Gaddafi, a warrant of arrest was issued because the ICC wanted to try him, for his crimes in Libya. And then he died before they could make an arrest. So that's an example. Now, what kind of crimes does the ICC try? 4 crimes at the moment, and honestly, if we look at the extent and the implications and the ingredients of these crimes, I suggest, or I would submit, that it might be impossible for the ICC to expand its jurisdiction in the future, because that would now mean that it will now start trying people for every petty things that local courts can already try. Don't forget that I said that if the local courts are actually willing to try, the ICC does not kickstart their jurisdiction. Only if the local courts are not willing to try, then the ICC can. That the ICC jurisdiction can be summoned or kick-started, and then they can try. So the crimes are aggression, war crimes, crimes against humanity, and genocide. Those are very serious crimes. So it's not just any petty or little crimes that the ICC would try. So that would mean that the ICC is a court of last resort. That means that when all else fails, when the state apparatus for trying crimes fail, that's when you then summon the jurisdiction of the ICC and come before it. So it's not a court that you run to for every little thing. It is a court that you go to as the last resort, the very last resort. And the ICC cannot impose a death sentence. It can only impose a life imprisonment, as the highest, sentence. If the ICC reaches a decision and the defendant is not pleased with it, they can always appeal that decision. So the ICC has an appeals chamber where appeals can lie, from its decisions. And indeed, some cases have been appealed before, before the ICC's appeal chamber. So how do you kickstart the jurisdiction of the ICC? When a matter is referred to the prosecutor, or the prosecutor decides to open a matter, or the United Nations Security Council refers a matter to the prosecutor's office. To open a matter, to open a case, the prosecutor conducts what is known as preliminary investigations, and that would review or must review three things. One, the prosecutor has to consider, is there a crime that's been committed that is of and is there evidence of the commission of this crime that is of sufficient gravity, to activate the jurisdiction of the ICC? That's one. Two is that, are there genuine national proceedings already ongoing on this matter, or is there a dearth, of any trial locally, for this offender, on this matter? Then three, will opening investigations in that matter, opening that case, will it serve the interest of justice and the interest of the victims of the crime? So these are the three things that the prosecutor will consider before deciding to open trial or to open investigations in any matter. So that is called preliminary investigations. Now, the standard of proof, is proof beyond reasonable doubts before the ICC, just like in any criminal matter, beyond reasonable doubt. Another thing that I would like to say is that, sometimes in African countries, especially in Nigeria, people look to the ICC as if the ICC has the ability to do justice that has not been done locally. Well, they may have that ability, but people tend to forget that a country can withdraw from the ICC at any time. So as African countries especially, our hope lies within us, not outside of us. So we must develop our judicial system, we must develop our court system locally to ensure that justice is done, that we do not even have to always or often refer or resort to the ICC. For instance, in 2017, Burundi withdrew from the ICC when the ICC decided to investigate, allegations of repression of human rights by the government of Burundi. It withdrew. In 2019, too, the Philippines withdrew from the ICC because the government of Philippines was on a war against drug dealing, drug abuse, in Philippines, and there were allegations of human rights abuse, killings, unlawful extrajudicial killings, in that process. So the ICC tried to investigate the matter, and Philippines withdrew. So if countries can withdraw, at their own whims and caprices, our hope does not lie in the ICC. We must do justice within our own lands, within our own gates as African countries especially. Also, the ICC is funded by member countries. So there might be, some propensities for politically motivated prosecutions. There have been such allegations. You can read up these things online. I even wrote a paper on the ICC, where I tried to look at the structures that we had before the ICC for trying crimes of international concern, and how the ICC came into being and what the ICC has done so far, just briefly. And then I tried to talk about, the prospects that the ICC has. Please read it. I'll leave a link to that paper in the description box. You can read it for further understanding of what the ICC really does. Then another thing I wanted to say is that, at some point there were agitations against the ICC. That is also not a solution. In fact, another court, a regional court for human rights was formed. It's called the African Court of Justice and Human Rights. I think that that's like reinventing the wheel at the slightest inconvenience. That is also not a solution. The ICC came into being because there was no permanent court to try crimes that are of grave and serious and international concern. Yes, there were some tribunals that were focused on some certain regions, but afterward, the ICC came into being to become a permanent structure. So we should work together to ensure that the ICC is very efficient. Countries cannot be pulling out just because the ICC is not doing their bidding, and countries cannot start their own simulation of the ICC just because they feel that like their interests are not being protected. We must all work hand in hand to make sure that the ICC works and it actually does justice, not only in Africa but the world as a whole. So that is all the basics that you need to understand about the ICC. It does not usurp the jurisdiction of the local court. It is not the last hope. It is a court of last resort, but it is not the savior or the messiah that we are looking for. We must do justice on our own soil. It sits at The Hague in Netherlands. It has tried 31 Africans so far. All cases that have been tried by the ICC successfully so far and unsuccessfully too have been African cases. Of course, the ICC has tried to open some other cases. They are currently investigating some cases, ongoing, that are non-African cases. But the records that we have for persons that have been tried by the International Criminal Court totals 31 Africans, and there are only just 33 African countries of the 123 member states of the International Criminal Court. So the court has a structure. It has the prosecutor's office, it has the presidency, so there are judges and all of that. So it has its mode of issuing a warrant of arrest, arresting the offender, trying them. They provide interpreters for people who don't understand the language, because there's no African language amongst the working languages of the court. Actually, no African language. So it's English, French, all those about six languages, but there's no African language as we speak. So these are considerations. I'm speaking from an African perspective, but what I'm saying is that the International Criminal Court is for the whole world, not just for Africa. So, and because it does not usurp the jurisdiction of the local judiciary, local courts must ensure that they strengthen their own internal states. Individual states, sovereign states must ensure that they strengthen, their means of doing justice locally before matters even get to the ICC. So that's all I want to talk about in this video. I will see you in my very next video. Don't forget to subscribe to do.